Experienced foreign investment attorney investing in U.S. real estate can open the door to a huge market and new ways to grow your portfolio, but the rules are not always like those in your home country. The United States has special tax withholding rules when a foreign seller transfers a property under the Foreign Investment in Real Property Tax Act, FIRPTA, and it pays to have clear guidance so you can move forward with confidence. If you're thinking about expanding your investment options or building a commercial presence, working with professionals who understand the U.S. landscape is essential. The U.S. does not have one simple rulebook for international buyers. Investment, tax, and real estate laws vary across jurisdictions and interact with your home country's laws in ways that affect your deal. Several states now restrict or condition certain purchases by foreign nationals or entities tied to specific countries, so always check state-specific rules before making an offer. A qualified lawyer who is experienced in cross-border transactions can look at property structure, contract terms, tax exposure and required filings, flag issues early and suggest options so you can make informed choices. At Sishodia PLLC, attorney Natalia A and the team handle purchases, sales and real estate disputes for international clients, acting as a steady ally focused on protecting your legal and financial interests while keeping you informed of your responsibilities and options under U.S. and New York law. Foreign investors can buy single-family homes, condominium units or commercial properties, but buying into a housing cooperative, co-op, is more complex because the buyer does not receive a deed. Instead, they buy shares in the corporation that owns the building and receive a proprietary lease. Co-ops are intended as primary residences and are generally not suitable as investment properties. Without a local credit history, obtaining a mortgage can be challenging, so many non-residents fund the purchase with cash, and those who do secure local financing may face higher interest rates and substantial down payments. For international clients who need someone who speaks their language and understands their culture, Sishodia PLLC has lawyers fluent in English and Russian who have represented clients from countries ranging from Russia to Italy and Japan. High net worth individuals, celebrities and global businesses rely on this law firm for precision, insight and stress-free closings. International investors must also navigate federal reporting rules. The Financial Crimes Enforcement Network's geographic targeting orders require U.S. title insurance companies to report the beneficial owners behind legal entities used in non-financed residential purchases in specified metropolitan areas, including New York City, when the purchase price is typically $300,000 or more. The current order runs from the 15th April 2025 to the 9th October 2025 and covers payments made via funds transfers, checks and even virtual currency. FinCEN's nationwide residential real estate rule, effective 1 December 2025, will extend reporting to specified non-financed transfers to entities and trusts, so investors should plan transactions with these dates in mind. In addition, most foreign investors buy all-cash newly developed properties, but with $3 million to invest, the same investors could buy 2 properties by putting 50% down and financing the rest. Federal banking regulators evaluate how well institutions meet credit needs under the Community Reinvestment Act, yet challenges remain when foreign buyers seek loans. FIRPTA requires buyers to withhold 15% of the amount realized when purchasing U.S. property from a foreign seller, though if the property is a residence costing $300,000 or less, no withholding is required, and if the price is over $300,000 but not more than $1 million, the rate drops to 10%. FIRPTA withholding is not the final tax. Sellers may file for a refund or seek reduced withholding with an IRS certificate. Estate and inheritance planning is another critical issue. Non-resident aliens are subject to U.S. estate tax on assets located within the United States, including real estate, tangible personal property and securities of U.S. companies. A non-resident's stockholdings in American companies are subject to estate taxation even if the certificates are held abroad. An estate tax return must be filed if the decedent's U.S.-situated assets exceed $60,000 and the rates range from 18 to 40%. Certain estate tax treaties may offer more favorable treatment to non-residents, and the estate of a non-resident alien may deduct the value of property passing to a surviving spouse if that spouse is a U.S. citizen or resident, but the unlimited spouse exemption does not apply when the surviving spouse is also a non-resident. Foreign investors purchasing property in New York City should weigh four major considerations: taxation on operating income and gains, repatriation of profits, taxation upon death, and privacy and reporting requirements. Without adequate planning, combined federal, New York State and New York City taxes on gains could reach 65%, yet proper structuring can reduce capital gain taxes on a sale to no more than 20%. Choosing how to hold the property also matters. Buying in your own name exposes you to liabilities and estate and gift taxes that can reach 40% for non-residents with only a $60,000 United States dollars exemption, and individual ownership lacks privacy and triggers a 15% FIRPTA withholding when you sell. A U.S. limited liability company offers liability protection and pass-through taxation but still creates estate and gift tax exposure and does not guarantee anonymity. New York law requires disclosure of every LLC member in residential deals, and entities formed after the 1st of January 2024 must report beneficial owners under the Corporate Transparency Act. Some non-residents use a foreign corporation to block U.S. estate tax because its stock is not U.S. situs property, while a U.S. C corporation may avoid FIRPTA but pay 21% corporate tax plus dividends and branch profits tax. Trusts can remove property from your estate, reduce income tax and protect privacy, and combining a domestic trust with a disregarded LLC may suit a vacation home. Large portfolio owners may accept branch profits tax to use a foreign blocker and avoid estate tax. There is no one-size-fits-all answer. Your home country, investment size, intended use and repatriation plans all matter, so consulting an attorney is key. Navigating U.S. real estate law requires serious understanding and planning, but you don't have to do it alone. A skilled foreign investment lawyer knows the laws, understands the justice system and can help you decide your next steps. Sishodia PLLC is a New York City law firm dedicated to understanding each client's unique goals and circumstances. Its international investment attorneys provide comprehensive advice and guidance to minimize risk and can explain each step in plain language. To discuss your investment needs, contact Sishodia PLLC at 833-616-4646 or visit their office at 600 3rd Avenue, 2nd floor, New York, 10016. With the right law firm on your side, you can protect your interests and pursue your investment goals confidently.